number 49, the people of the state of New York versus Stanley Hardee.
May it please the court, Rachel Goldberg on behalf of Stanley Hardee. I'd like to reserve 2 minutes for rebuttal, please.
You may, Ms. Goldberg.
Thank you. In order for police to search a car after a stop for a traffic infraction under People v. Torres, police must have both reasonable suspicion of a crime and there must be a substantial likelihood that there's a weapon that poses an actual and specific danger.
So, Ms. Goldberg, if I can interrupt, before we get into a discussion of whether Torres is applicable here or not, why is this even reviewable? Why is this not a mixed question of law and fact where our review is somewhat limited?
So putting aside whether the appellate division used the wrong standard under Torres, the facts don't meet the minimum standard for a legal car search in the first instance, which takes this case out of mixed question and into a question of law under Bigelow. So there was the facts don't meet the minimum standard for a car search because there was no substantial likelihood of a weapon that posed an actual or specific danger. As a threshold matter, there was no reasonable suspicion of a crime after a traffic infraction. The police pulled Mr. Hardee over for speeding and changing lanes without signaling, bad driving to be sure, but no crime had been committed, and nothing he did after that point gave the police reasonable suspicion that he had committed a crime.
Slow down. When they pulled him over, there were 2 drinks with alcohol in the front seat, right?
That's correct. Those are traffic violations.
Right. And then there was also, he was asked to step out of the car 3 times.
Correct.
He didn't step out the first time when he was asked. He didn't respond to the request from officer. And then finally, there's, I think, the more factually problematic question of resisting arrest when the officers were putting cuffs on him in the back of the vehicle. I think it's fair to say I'm not sure if the record is entirely clear as to when that happened in relationship to the search of the back.
Sure. So Officer Loud specifically testified that the struggle had not begun when he searched the car. And in fact, he said, this is on page A66 and A170 of the record, that he would not have searched the car if the struggle had begun. So at the time that Officer Loud searched the car, there was no crime and no reason.
So is it your position that this struggle took place before or after the search?
At best contemporaneously, but certainly not before, which would.
All right, and then but you would say that if it was either simultaneously or before, then clearly it meets the legal standard. Because this was not a case of there being no incident. This was not without incident in the terms of our case law.
Officer Loud, the reason that he searched the car and the reason he said he searched the car was because of Mr. Hardee looking in the back seat and refusing to get out of the car, and the fact that one of the other officers frisked him. So the struggle in the back of the car had nothing to do with the search, and that's what courts have to review, is whether or not at the time of the search there was legal reason to do so. So if Mr. Hardee had begun resisting arrest or struggling before the search, and that was part of the search, it still wouldn't have met the standard.
Isn't that part of what's so hard for us to review here? Because this is clearly, I think it's Judge Fahey saying, an escalating situation. They pull him over, as you said, it's a signal, whatever. There's alcohol, there's this interaction where they finally have to get him out of the car after a couple of times. He's in the back, that's escalating. There's somebody else in the car. They have these other indicators. And we're looking at this record as when exactly does this happen? So what split second was he resisting, or could this other officer have gone into the car when there's another passenger and there's someone who at best is about to get into this altercation in the back of the car? How do we parse that record to come up with, as a matter of law, this was a violation of our standard?
Because the court's job is to look at all of the facts and decide when it would have been appropriate for the police to.
But I don't think that's the court's job, isn't to look at all of the facts. The court's job here is to look at whether they applied the right standard here, and we really can't get into the facts.
But given
so
those
based
facts,
on this record, which and the question is this a mixed question of law and fact? Are we going to say as a matter of law this decision is wrong?
The facts are clear. I mean, all Mr. Hardee was doing was looking into the back seat where there was a bag, where Officer Loud saw a bag. He refused to get out of the car 3 times, but then he got out voluntarily. He, in the words of the police, he was compliant during the frisk. He was at the back of the car. His companion had already been brought to the back of the car. So
See,
at that point,
To follow up on it, it's the ambiguity in the facts, because you certainly have not misstated the facts. I don't mean that, but there are other things that the officers said, like they thought he was looking around and planning on running. Ciani, one of the officers said something like that. And that's what led to the cuffing of it. And I guess it's the ambiguity in the facts that make this a particularly difficult case.
If he was looking to run, if in fact they thought he was looking to run, would that provide a basis under the correct standard to search the vehicle?
no. This is a very narrow standard. This is an exception to an exception. So you need reasonable suspicion of a crime and a substantial likelihood of a weapon. So somebody who's been taken out of the car and frisked with no weapons, who runs from police, that doesn't give any indication that there's a weapon in that car, and that's what this is about.
For the purpose of applying the standard, do we care about what the officers who were present knew collectively, or what the officer who conducted the search knew?
So here, it's whether the search was objective based on the officer's knowledge.
But the officers collectively,
searching
or the
officer?
officer?
The searching officer,
Searching
yes.
officer.
And from, Officer Loud did not have the predicate to search the car. There was no reason for him to believe that there was anything in that bag that was a contraband, much less a weapon. So,
But doesn't it also have to be, not just that there's a weapon in the car, but that there's a danger that that weapon is going to be accessed or used?
that's right. That's right. And it can't just be theoretical. I mean, this court has clearly rejected that test. It has to be both.
How do you reconcile this case with Mundo?
So in Mundo, it was a traffic stop, and the driver repeatedly tried to flee from police, playing this dangerous cat and mouse game. So he would slow down, the police would get out of their car, he would flee. He almost ran over a pedestrian. He was seen stashing something under the seat. So he clearly was, potentially setting a trap for police officers. He likely had a weapon in the car. So in this case, there was nothing like that. Mr. Hardee pulled over, the police
Well,
testified
don't we have
that-
police patrolling in an area where there's a reported spike in crime? This guy, the police officer testifies, goes flying by at 50 miles an hour. He's weaving in and out of traffic. He's not signaling that he's moving. He disobeys 2 commands of the police officer. He's nervous. He's looking around. He keeps looking into the back of the car. He gets out of the car. He's not, I wouldn't say he's resistant initially, but he's giving the police cause for concern.
Right.
Is the only thing missing? That he makes a furtive movement under the...
No, but we already have, so police are allowed to order people out of the car, and the legality of the frisk wasn't litigated, but they frisked Mr. Hardee. So they are allowed to take these steps in recognition of the inherent dangerousness of police work. And yes, there was a spike in crime, which is exactly why there were more patrol officers there pulling people over for traffic infractions. But
Exactly.
that doesn't that doesn't give the officers in this particular case reasonable suspicion and substantial likelihood of a weapon.
It seems you have 4 factors here that distinguish his case from Torres. Nervousness, number 1, refusal to get out of the car, the looking around, the officer characterized it as looking to where he was going to run. Who knows? That's the 3rd factor. And then, of course, fighting with the officers, which is clearly a matter of, clearly an incident, though I think there's a fair imputation that we're not sure what the timing of that was. But those 4 factors seem to take it way beyond Torres.
Well, Torres is actually helpful. This was a murder suspect, that the police got a predictive tip that this murder suspect was going to be at a location, driving a specific car with a gun in a shoulder bag. And sure enough, he pulled up, the same guy, in the same car with a shoulder bag. So the police had reasonable suspicion that this person had committed a homicide, and substantial likelihood of a weapon in the car, but they still couldn't search the car. So I think Torres is actually helpful here because
Is that based on an anonymous tip?
it was based on an anonymous predictive tip, so it was presumed reliable. And, so in this case, it was a traffic violation. This wasn't police pulling over a murder suspect, and there needs to be real protections for people who speed or want to run a stop sign, and the police pull them out of the car, frisk them, and we have a high bar for going into their car. Thank you.
Thank you, Ms. Goldberg. Counsel?
Good afternoon. Jessica Olive on behalf of the people. May it please the court. This case presents a standard mixed question of law and fact that is beyond this court's review because there is ample record support for the lower court's decision. And defendants' new argument for a change in the legal standard by requiring reasonable suspicion of a crime is unpreserved and entirely meritless. First, this is a mixed question of law and fact.
Well, you agree that there has to be an actual and specific danger of a weapon in the car, correct?
That's correct, Your Honor.
So I think one of the questions is do you have to, how do you distinguish between whether there's a weapon in the car or maybe some other type of contraband? So here you have somebody, he's looking around, he seems to be nervous, he's got some alcohol in the front seat, but what, if anything, is there to tell the officers that there may be not that there may be, that there's a likelihood that what's in that car is a weapon?
Your Honor, first of all, we do not need to establish that the presence of a weapon was the only conclusion to be drawn from the circumstances. We don't even need to show that it was more likely than not, because the standard is less than probable cause. And here, the substantial likelihood of a weapon present is shown most prominently by the fact that he's repeatedly looking at a shopping bag.
Yeah, but how would, then in every single case, no matter what the contraband is, that would apply, right?
The officers do not need to rule out that the item that the occupant of the car is preoccupied with could be something more innocent, such as drugs or alcohol.
The standard doesn't say substantial likelihood that there's contraband in the car. It says a weapon. So there has to be something to distinguish.
Well, it's the occupant's
So,
preoccupation.
for example, if he was wearing a bulletproof vest, we've already recognized there's a substantial likelihood. Maybe that's a little bit to the end of the spectrum there, but it seems to me that there has to be something.
Well, this case is very factually similar to People versus Mundo, where the occupant of the car is seen stashing something in the back seat that shows a preoccupation with an item in the vehicle that could be a weapon. And similarly here, we have a preoccupation with an item in the vehicle that could be a weapon. These officers are faced with this uncontrollable, dangerous situation. We cannot require them to eliminate all innocent possibilities.
But isn't that partly of their own doing? The defendant was removed from the car, okay? And haven't we said that, if there's an alternative, like if you're afraid there's a weapon in the car, you've got him out of the car, move him further from the car so he can't access it. Why couldn't that have been done here, and why isn't that relevant?
These officers are faced with making split-second decisions in a very uncontrollable situation.
But that's why they get to remove him from the car.
Absolutely. We're looking at what the protective measures that the officers did take, whether those actions were in fact reasonable, not whether they could have taken less intrusive measures.
But there is language exactly like what Judge Stein is describing from Torres, which says exactly that. I mean, do you read that as dicta, or how do you distinguish that from what happened here? Because I read that passage and it sounds exactly like what happened here. Bag in the car, occupants out of the car. The court says if the officers were worried, they could just move the people away.
Well, in Torres, the occupant and the defendant in that case was not acting nervously, was not potentially high, was not refusing to get out of the car 3 times, was not ignoring.
We're talking about the point where both of the occupants are out of the car, right? They're already out of the car before Officer Loud goes in to conduct the search, yes?
That's correct.
Okay.
But all of the defendant's behavior before the search was indicative of a danger to the officer's safety. He's speeding down the highway, he's weaving in and out of traffic, he's not listening to the officers, he's refusing to get out
Once
of.
they're removed from the car, where is the danger? And can't that danger be ameliorated by saying, could you move forward, move away from the car?
The Torres-Carby-Mundo test is looking at whether there's a risk of a weapon in the vehicle, notwithstanding the suspects in
A risk of a weapon in the vehicle or a risk to the officers?
It's whether there's a likelihood of a weapon present in the vehicle that presents a risk to the officers. But the test is notwithstanding the suspect's inability to gain immediate access to the weapon. The question is whether in the course of the officers conducting their lawful duties during a lawful stop, whether if the defendant, if he was somehow able to escape from the officers, or whether the other occupant of the car would be able to gain access to a weapon within the vehicle. So the question
Isn't that exactly what we sort of rejected in Torres by saying the hypothetical or theoretical possibility that when the stop is concluded, the occupants get back in the car and then turn around and shoot the officers is not something we're prepared to.
This is not based on a theoretical possibility. It's based on this suspect's behavior throughout, before, during, and after the stop. And in addition, you have this
But
other.
doesn't it matter that the officers themselves say he's compliant? He's compliant at some point. When he's removed, he's outside, he's now compliant.
Well, the defense is asking.
Anyway, vitiate whatever happened before?
No, Your Honor, because while the officers are telling the defendant to get out of the car, he's almost immediately looking behind his right shoulder at a shopping bag that's in the back seat. He's shaking his head, no, I'm not getting out of the car. He's looking at the officers, he's looking at his passenger.
Once he's out of the car,
Once
did they
he's-
not say he's compliant at that point?
He was not compliant. He continued looking over his left shoulder now into the back seat of the car at least 2 times, even though the officers are telling him, stop looking back, stop looking back. And he's looking.
Doesn't it ultimately, though, taking it a step further, go down to what, I think it was Carvey that used the language, did the arrest or did the stop take place, the search, take place without incident? And so the question really comes down to whether we could characterize this stop as without incident. And it wasn't without incident. It took 3 officers to subdue this defendant. So the question, so since there was incident, this is not just somebody who's complying with every police officer request. The question is the timing of that incident, and if that's a mixed question of law and fact, or whether or not it occurred so clearly after that it can't be right.
That's correct, Your Honor, and this is clearly a mixed question of law and fact because the defense is asking this court to draw contrary inferences from the facts.
Where is there proof in the record that Officer Loud knew that there was some scuffle going on in the back of the car at the time that he began the search?
When Officer Loud began the search, that would be at most contemporaneous with the handcuffing. Prior to that, though, he was still.
We're guessing on the time, but what evidence is there that he knew that that was going on? Is there any evidence in the record to support that?
The time that Loud conducted the search was sometime between the frisk and the handcuffing, or at most contemporaneous with the handcuffing. It's not the people's position that he began conducting the search after the defendant was already resisting handcuffing. But it does appear that it was most simultaneously with that. But prior to him resisting arrest, he's already not listening to the officers.
No, but
he's already.
Isn't the question his knowledge? So regardless of the exact moment or what he was doing or whether it was without incident, doesn't the searching officer have to know about the incident before he or she searches the vehicle?
He's already, this incident, or this car stop was already without incident. He was already, planning his escape route, not listening to the officers. He's preoccupied with an item behind the front passenger seat that Officer Loud sees him looking at while he's still in the car. The fact that his suspicions were borne out by the fact that the defendant ends up resisting arrest and it takes 3 officers to subdue him only makes his actions even more reasonable.
But isn't the record unequivocal that Officer Loud kneels on the front passenger seat, looks in the back, and at that point in time, he doesn't know there's a scuffle going on. He looks into the bag, he sees another bag inside the bag, he sees a butt of a semi-automatic weapon sticking out of that bag, and then he starts leaving the car to say gun or the code word for gun, and that's when he sees the scuffle. Isn't that unequivocally the evidence?
That's correct, Your Honor. He performs a limited search of the bag that he saw the defendant looking at earlier.
Before he knew there was a scuffle.
Yes, Your Honor, that's
Well,
correct.
Does he feel the bag first?
Yes, he does.
And what does he feel?
He feels a weight that would be consistent with a weapon.
All right, so he does that before he actually opens the bag and looks in it.
That's correct, Your Honor. And he's only looking at this one area behind the front passenger seat, which is where he saw the defendant looking. It was a limited search, and it was reasonable under the circumstances. We ask that you affirm. Thank you.
Thank you. Ms. Goldberg?
Your Honors, Mr. Hardee was not acting in any way that would show a disregard for safety or that indicated an actual and specific danger of a weapon in the car. Even if there was a scuffle.
Can the police take into account his speeding and his weaving and his disobeying of the police command?
Well, that's why they pulled him over for a traffic infraction. And
And then
that was
what do they
legal.
do? They excise that consideration?
Well, no, but you need much more to escalate
Understood,
into
but
a
can they
search.
consider that as part of the equation?
Yes, I think it doesn't add much to their concerns. He was doing what lots of bad drivers do. He was speeding and changing lanes without traffic. There was nothing in the record to indicate that the police believed we're going to charge him with reckless driving or
What about the
anything like that.
reported spike in violent crime in that community? Does that go into the mix? Is that permissible?
The test here is whether there's reasonable suspicion of a crime and substantial likelihood of a weapon that posed a danger. The spike in crime in the area, doesn't factor in at all, or at least very minimally, into this particular case and these circumstances here. There was no, the police weren't responding to a call about a crime. Unlike Mundo, Mr. Hardee was not actively putting anybody at risk.
Counsel, and I know your time is almost up. but
Sure.
Judge Wilson was asking us a scenario here. The searching officer's in the car, leaning over the seat. There's the person in the back who's being cuffed and looking out, not yet resisting. Clearly, if that officer, there's another passenger on the side, the officer sees this altercation or resisting arrest, they can look in the back. You agree with that?
Actually, so the scuffle alone is not enough under our law because there's no substantial likelihood of a
Scuffle with
weapon.
4 passengers now on the side of the car.
But
Is that enough?
there's nothing that says there's a weapon.
Everything they have so far with all the looking and so they have to wait and determine, and it could be, it's not going to be a bulletproof vest in most of the cases. So that would pretty much make it, you never know it's a weapon. I mean, somebody could be looking for heroin. They have a heroin kilo in the back of the car. You could always say that. It's a heroin, it's a
Or
kilo.
in this case, a vodka bottle.
Right.
Well,
So that can't be the test. I mean, if you have to see the butt of the gun, you're already there. So what's the test then? If it isn't a bulletproof vest and it isn't the butt of the gun sticking out of the bag, what's your test for there's a weapon?
So for example, in Mundo and Carvey, the person was trying to hide something, which indicates that it's
hide a
contraband of some
kilo.
kind. Sure, but
Contraband.
But here, just looking at a bag and not trying to hide it from police, it could have been something he didn't want his girlfriend to find.
So it's the hiding that then gets you a gun?
In conjunction with actively endangering other people and showing a willingness to endanger other
But
people.
you're saying the resisting, which some might say shows a willingness to endanger other people, wouldn't be enough on these facts then, because you don't know it's contraband.
But Mr. Hardee, the search happened before.
No, but I asked you in the hypothetical, if he looks out the window and he sees that scuffle going on, you said still not enough, he doesn't know it's a gun.
I think under those facts, there's no indication that there's a weapon, but given these facts, it doesn't meet the minimum threshold for a legal search. Thank you.
Thank you, Ms. Goldberg.